There's nothing funnier than watching folks in the mainstream media, specifically Joe Scarborough and his stupid wife, be absolutely shocked when everything they've been saying blows up directly in their face. And on the issue of due process for illegals, it's over for them.
Review. How is that not a violation of the Fifth Amendment, but suddenly it's a violation of the Fifth Amendment if the Trump administration does it?
Well, the short answer, back then we're talking about immigration law. The Alien Enemy Act is actually not part of immigration law.
So we have three things, and as we said, excuse me for interrupting, but we have the Alien Enemy Act, which the South Texas judges said is illegal. We have what's happened in Venezuela, but then we have general deportation. That's what I'm talking about right here.
Yep. So federal law allows for even broader and speedy removal than has been used in the past. And expedited removal, as you talked about, allows for summary removal. That means no entitlement even to a hearing, possibly within 24 hours. It hasn't been used as broadly as, say, the Trump administration might want to use it. But under the statute, it is permissible to remove aliens who arrive at the border and even those who have been here for 2 years, although that 2-year provision you talked about is the lesser used in practice. But just because it isn't used very often doesn't mean it's not a part of federal law that can be used. And it will be used because it's permitted under federal law. The Congress, in its infinite wisdom, decided that aliens who arrive at the border, and they define people who arrive at the border as people who have even been here 2 years, if they have fraudulent documents, if they don't have sufficient documents, they can be removed in an expedited fashion unless they seek asylum. So you don't run into those due process concerns, at least presumably because that statute, as it exists today, is still valid. Now, that's not what's at stake with the Venezuelans and the Alien Enemies Act. But the government's argument is that, hey, court, listen, you're telling us we need to provide notice. Well, take a look at this federal law. It says that we don't even need to have a hearing. It can happen within 24 hours. So if that's good enough for people who arrive here who are aliens, it's certainly okay for people that the president has deemed to be alien enemies.
And of course, that's been the problem. A lot of the problems with the court is they didn't just go the way Barack Obama did. They did Alien Enemies Act. They went back a couple of hundred years for an act that doesn't even apply now because we're not at war with Venezuela, first of all. And then secondly, again, it's one thing to deport somebody back to their home in Honduras. It's quite another to send them to the most heinous prison in El Salvador.
And the president has said again and again in the last couple of days, well, what are we going to do? Have 20 million trials, Danny, for these illegal immigrants? The point you're making is there won't be trials in the sense that we view criminal defense trials. You're going to get the OJ trial 20 million times over if he tries to deport people. So let's take Abrego Garcia, for example. If Garcia comes back to the United States and stands trial or has a hearing, what does that look like as an example of what others might face?
Yeah, Garcia's a little different. He wasn't removed under the Alien Enemy Act because he's not a Venezuelan. And so that whole argument about Venezuela being the enemy or Tren de Aragua being the enemy doesn't apply. But you're absolutely right. If he comes back, what due process is he even entitled to? Well, probably the government will go back to the immigration court and challenge or reopen his case. Because remember, the only thing that kept him here was a withholding of removal order from, I believe, 2019. So they can go back to that court, try to reopen that case and say, hey, since then, he's done some bad things. Now, factually, you can argue, hey, no, he didn't do any of these bad things.
But Danny,
even
that's just limited to don't send him back to El Salvador. They could deport him to Honduras.
Exactly. You make a really good point, which is, again, everyone's saying, hey, bring him back, give him due process. But that due process may mean he can go to any of the other, 200 or so countries other than El Salvador. And that's why I'm cautioning folks. This whole idea of due process, everyone's saying it, well, this is what they're entitled to, the Supreme Court said. But as a criminal defense attorney, I can tell you that due process sometimes feels a little hollow. Going to your point about habeas, I file habeas petitions all the time. It's a slightly different statute because I'm usually dealing with criminal defendants. These are detainees. But the vast majority of habeas petitions are denied without even an evidentiary hearing. In fact, rare is the case where you get an evidentiary hearing. For criminal defense attorneys, any of you watching now, you're thinking, oh my gosh, I got a hearing on my habeas petition, because most of the time they get tossed. And it makes sense because anyone who knows prisoners or the way they litigate, they file a lot of habeas petitions. And your point is spot on. If there was a hearing for every habeas petition, the courts would shut down.
All right, MSNBC and
Wait,
NBC.
we have to ask you one final question.
Okay. Legal analyst.
iPhone or BlackBerry?
iPhone or Black?